Welcome to The Explainer. Now, have you ever wondered if your private thoughts could somehow be used against you in a court of law? I know, it sounds like something straight out of science fiction, but under India's new evidence law, the Sakshya Adhiniyam, your state of mind can actually become crucial evidence. So today, we're going to dig into exactly how and when that can happen. So let's just jump right in with the big question, the one that gets to the absolute heart of all this. Can your private thoughts, your intentions, your state of mind be used against you in a trial? It feels like it shouldn't be possible, right? But this is a very real legal concept we're talking about. And the answer, which might surprise you, is yes, they absolutely can. But, and this is a huge but, it comes with a massive condition. Your thoughts can only be used if a very specific condition is met, what you can think of as a golden rule that decides when the door to your mind gets opened in a courtroom. So, what exactly is this golden rule? Well, it's the main idea behind Section 12 of the new Act. And it's not about just any random thought or feeling you have being thrown into evidence. No, it's all about providing a really specific context for when your mind truly matters in the eyes of the law. The entire rule really hangs on this one legal idea called a fact in issue. Now, don't let the legal jargon throw you off. Just think of these as the absolute core questions that a court has to answer to reach a verdict. You know, like in a murder trial, a key fact in issue is, did the accused actually cause the victim's death? It's one of those foundational questions. And this brings us right to the golden rule itself. Your thoughts, your intentions, even your physical feelings are only considered relevant evidence if that state of mind or body is itself a fact in issue, meaning it's one of those central questions that the entire case revolves around. Let me give you a really simple example of how this works. In a murder trial, the question, did the person intend to kill, is a massive fact in issue. So, of course, their state of mind is totally relevant. But what about a parking ticket? The court doesn't care one bit if you meant to park illegally. The only question is, was the car in the wrong spot? Your state of mind is completely irrelevant there. See the difference? Okay, so we've got the rule down, but let's go a little deeper. What does the law actually consider a state of mind? You might be surprised at just how broad this category really is. The law actually breaks it down into a few different buckets. You have the obvious one, intention. That's like pointing a gun before firing. Then there's knowledge, for example, knowing that the goods you have were stolen. But it also covers more abstract things, like acting in good faith or being negligent, like causing an accident while texting. Even a feeling, like ill will towards someone, can be a legally recognized state of mind. But here's the thing. The law doesn't just stop with what's going on in your head. It also takes into account the physical state of your body. And this is where things get really, really fascinating. This category is called bodily feeling or state of body, and it's all about concrete physical stuff. We're talking about physical injuries that are detailed in medical records, or even a person's spoken expressions of pain. All of these can become relevant facts in a case as long as that physical condition is a core question that needs to be answered. Okay, but here is a legal twist that I think is pretty wild. A condition like unsoundness of mind, what most of us would call legal insanity, is legally classified as a bodily feeling, a state of the body, not a state of mind. Now, why is that? Well, the thinking is probably that the law needs something that can be observed and diagnosed, almost like a physical illness. So in the eyes of the law, a mental illness is treated more like a physical condition. Look, theory is one thing, but the best way to really get a handle on these ideas is to see how courts have used them in real historic cases. These stories are what really bring the law to life. So first up, we've got a classic case that shows us exactly how a court goes about proving that really tricky thing we call intention. So in the case of R versus Holmes, you've got a defendant charged with murder, but the prosecution has a problem. There's no confession. So how on earth do you prove what he was thinking? Well, what they did was present evidence of his past actions, previous threats he'd made to kill the victim, and a history of fights they'd had. And here's the key takeaway. The court allowed all of that history as evidence. Why? Because it pointed directly to the defendant's state of mind, specifically his ill will and his intention to cause harm. His past actions literally became a window into his mind at the time of the crime. Next, let's talk about one of the most famous cases in all of law. You might have heard of it as the snail in the bottle case. This thing is basically the foundation of modern negligence law. The facts of the case are as simple as they are well, disgusting. A woman is drinking a bottle of ginger beer, gets to the bottom, and finds the decomposed remains of a snail. Yikes. She got sick and sued. The manufacturer's defense was basically, hey, it was a freak accident, not our fault. But the court completely disagreed. It found that the company's failure to have a good system for inspecting its bottles was direct evidence of their state of mind, specifically negligence. Their carelessness, their lack of a proper process, was a culpable state of mind that had very real consequences. Okay, and for our final case, let's circle back to that wild legal twist we talked about. This is the case that really explains why legal insanity gets treated as a bodily feeling. So, in Macnaghten's case, a man tried to assassinate the British Prime Minister, but he killed his secretary by mistake. He believed he was being persecuted. This case established the legal test for insanity that's still used today. Basically, was the person's mental state so broken that they couldn't understand what they were doing, or if they did, they couldn't understand that it was wrong? And this just illustrates the whole point perfectly. Macnaghten's mental illness, his bodily feeling, in the eyes of the law, became the central fact and issue of the entire trial. And because his state of body prevented him from having a guilty state of mind, it ultimately cleared him of criminal responsibility. Which really leaves us with one final thought to chew on. This entire area of law is built on the idea that our actions on the outside, our words, our carelessness, our history, can reveal what's going on inside our minds. But what is the law truly seeing? Is it seeing our actual, true intent? Or is it just seeing the imperfect reflection of it that our actions create? That's something to think about.